Although to my defense, I would have been on time had I not misread the song.
Yeah.
Which isn't really a defense.
You have a better excuse than that. Well, I had my shot 2 days ago, and I was reacting not really strong, but not good yesterday when I went home. So, and this morning I still was kind of out of it.
Yeah, that was me. I was like, I just didn't want to actually do anything.
I had 101 fever, and then they sent me home because of that. And I never take my laptop home anymore.
I never take my temperature. I had no idea. I definitely had a fever.
I
I had to. Oh yeah, I was home.
And so I went home, and then this morning I don't feel bad anymore, and I'm feeling okay now, but I'm real achy and just out of it.
Yeah.
And I just took right off with my laptop.
You just feel like binge watching something. That's about the greatest ambition you can muster.
Oh, I watched Netflix for like 4 hours yesterday.
Yeah. All right. I think, Ms. Farrell, you all set? Okay. All right. We are set on the computer. We are set in the courtroom. We are getting set in the jail. Are we on Court Smarter? We're going on now.
Yeah, mine's gonna go first. Ian was here.
Oh, okay.
Yes. Judge.
NJC, can you hear us?
We can hear you.
All right.
Okay, good morning, everybody. Welcome to Drug Court. I'm Judge Martin. We've got 2 matters on the docket this morning. Both are pleas. I should have Mr. Erlinson. Okay, and Mr. Trujillo?
Yes, ma'am.
Okay, very good. And it looks like, Mr. Erlinson, you've got regional counsel, and he had to go into another courtroom, so I'm going to speak first with Mr. Trujillo. But I'm going to invite you to listen in carefully, and then Mr. Trujillo can, if the jail will let him, Mr. Trujillo can hang out while I talk to you second, Mr. Erlinson. The reason being, I'm going to go over the rules of drug court. You guys have different cases, different charges, different contracts, but the rules are the same for both of you. And it can be a little bit easier to absorb that when you're not the guy in the hot seat. So it also can be beneficial to hear it a second time. So that also will allow us, if you think of a question after you sit down or anything like that, we can just be sure to cover all our bases. So I'll call Mr. Trujillo forward first, but invite Mr. Erlinson to listen in when we get to the discussion of all the rules and so forth. Okay, good morning, Mr. Trujillo.
Your Honor?
Yes, ma'am.
We also have Janet Jackson. Did you not meet her? She's on the docket.
She is not showing on the docket. Yesterday, she was showing for next Thursday, the 20th. I have spoken with the attorneys. Do we? I don't show her.
She was on 24th yesterday, and Judge told her next week she was on the docket.
Okay. So I think and I don't know if we need to put anything on the record. Do you have that, even have that case number? Hold on, I may. Is it still, I think state responded last week that we would wish to see Ms. Jackson next week, that we don't have anything in.
18 CF 1846.
That's when we look on the top one.
Nope, that's the same docket I have.
Okay.
Yeah, thanks.
Can I speak?
Hang on one second. Yes, she's on for next week. 18 CF 1846, Janice Jackson. I'm showing for May 20 at 10 a.m. and I think we want to just leave her set for
Just leave her there.
then.
Okay.
Mr. Darrow, I'm not showing you guys for Ms. Jackson, but you all were in the past, I
If we were in
think.
the past, also I'll notice on her this time.
Let me just,
All right, laptop.
let's see here if I can tell. The order for release on recognizance showed you. I think you guys were on, yeah, you were present in February.
I know that I've handled stuff for her in the past. I just
Yeah.
can't remember if it was.
You represented her when we had her in February. So so then it looks like you'll file a notice of appearance.
I'll do notice appearance.
Okay. So we can let Ms. Jackson know that Mr. Darrow's office will be in touch to talk to her, figure out what the options are going to be, and I will see her this time next week.
Okay, thank you, Your Honor.
Thank you. Okay. All right, back to today's docket, and if the state wants to call the docket, starting with Mr. Trujillo.
Here, Mr. Trujillo has 21 CF 105 and 21 CF 377. 21 CF 377 has a consolidated misdemeanor case. The DUI was consolidated.
Okay.
Did you want the term?
Yes, please.
Oh, okay. I didn't know if that's what you
Yes, please.
In 21 CF 105, he's going to be entering a plea of no contest, driving while license suspended or revoked. Third or more, a first-degree misdemeanor, resisting without violence, and possession of a controlled substance. He'll be adjudicated guilty on all 3 charges. As to the driving while license suspended and the resisting, the sentence will be time served. As to the possession, it'll be 4 years of state probation, the first 2 of which will be served on drug offender probation, which will run concurrent with 21 CF 377. Special conditions are to enter and successfully complete drug court following all treatment recommendations. 10 p.m. until 6 a.m. curfew unless it's modified by the court or probation. Attending recovery support group meetings and submitting truthful reaction sheets to his case manager if treatment directs him to do so. Following all recommendations of the clinical assessment. Being tested for alcohol, controlled substances, and unapproved medications at a minimum of 1 time per week by treatment and 1 time per week by probation. And no possession or consumption of alcohol, nor frequenting any places that primarily sell or serve alcohol. Based on the adjudication for the possession charge, there's a mandatory 6-month driver's license revocation. The state has no objection for business purpose only license if he qualifies. There's $100 cost of prosecution and $215 cost of investigation to the sheriff.
Okay.
And I noticed, Your Honor, in 21 CF 377 that there are actually 3 DUI-related counts on the docket. I believe at least 2 of those must have been considered filed by citation. The state's only going forward on 1 count of DUI with property damage, and there's only 1 count on the score sheet.
Okay.
So the state would not announce an all-cross on 3 and 4 upon acceptance of the plea to 1 and 2.
Okay.
The conditions of 1 and 2 are both adjudications. On count 1, 4 years of state probation, the first 2 on drug offender probation, and 12 months concurrent on the DUI with both count 1 as well as the previous case. Again, the same conditions of probation relating to drug court, the curfew, the meetings and the reaction sheets, the testing, and the no alcohol clauses will be the same in this case. There are mandatory special conditions of the DUI, which will be 50 hours of community service, completing DUI school, attending the victim impact panel, impounding the vehicle he was driving or any one vehicle belonging to the defendant for 10 days. An ignition interlock must be installed on all of his vehicles for 6 months. There's a $1,000 fine. As a condition of probation, defendant shall pay restitution to confidential victim. I do have a confidential victim order in the amount of $1,666.59. That's 166659, and a minimum of $167 per month, starting 30 days from his release, and also no contact with special victim. There's a mandatory 6-month driver's license revocation on this possession charge as well as a 12-month driver's license revocation on the DUI. It will be up to the Department of Motor Vehicles whether those counts run concurrent or whether everything runs consecutive that he's playing to today.
Okay.
There are $100 cost of prosecution and $509.50 cost of investigation to the sheriff.
Okay. Anything else?
Anyway,
All right. Mr. Darrow, is that all consistent with your office's negotiations?
Yes, that is what the contract.
Mr. Trujillo, could you hear everything the prosecutor just explained to me?
Yes,
Did you understand all those terms and conditions?
yes, I do now.
Do you want to accept those and resolve both your cases by coming into drug court today?
Yes, ma'am, I did.
Would you raise your right hand to be sworn, please?
Do you swear or affirm that the testimony that you give shall be the truth, the whole truth, and nothing but the truth?
Yes.
All right, the state attorney is going to ask you some questions to qualify your pleas.
Sir, can you please state your full name and your date of birth for the record?
My name is Hugh Trujillo. I was born 1982.
Can we have the last four digits of your social security number, please?
The last four,
Yes, please.
7753.
Sir, where were you born?
I was born right here in Naples.
Okay, do you have any issues reading or writing the English language?
What?
Do you have any issues reading or writing in English?
No, ma'am.
Okay, well, these are questions we ask everybody. Don't take offense.
Okay.
All these questions are asked of every person who enters a plea in the state.
Yes, ma'am.
Now, how far did you go in school?
I went to the 11th grade and I quit.
Okay. Do you suffer from any mental health issues?
No, ma'am.
Are you at this time under the influence of any drugs or alcohol?
No, ma'am.
And are you taking medication that's prescribed to you by a doctor right now?
Like, for what?
Any
Like, my
kind,
diabetic kind of pills?
any kind of medication. You don't have to tell us what kind. We just need to know if you're on
Okay.
anything.
Yeah, I'm some minor pills, but nothing for mental stuff.
Okay, so nothing that affects your mind at all. Is that correct?
No,
You understood everything we've said in all your attorney's conversations?
I did, ma'am.
Okay. So in case number 21377 CF, you were charged with driving while license suspended or revoked. Third or more, that's a first degree misdemeanor, carries a maximum penalty of 1 year in the county jail. Resisting with violence, without violence, also a first degree misdemeanor, same maximum penalty. And finally, a possession of controlled substance, that's a third degree felony, carries a maximum penalty of 5 years in state prison should you violate your probation. Do you understand what you're charged with?
Yes, ma'am.
How do you wish to plead to those three charges? Guilty, not guilty, or no contest?
No contest?
All right, and in case number 21 CF 377, you're charged with possession of controlled substance, again, a third degree felony, and DUI with damage to person or property, a first degree misdemeanor. That carries a maximum penalty of 1 year in the county jail if you violate your probation on that count. How do you wish to plead to those two charges?
No contest.
Have you read a copy of a plea form while you were waiting for us?
Yes, ma'am, I have.
Do you understand all the rights that are listed on the front of that form that you're giving up by entering a plea to both your cases today?
Yes, ma'am.
You understand that as a result of your plea, there will be no trial. There will be no requirement that the state present evidence and witness testimony to prove that you're in fact guilty of all your charges beyond a reasonable doubt to a jury. You understand that waiver?
Yes, ma'am.
We're also giving up your right to see the state's witnesses and evidence being questioned on your behalf by your attorney. Do you understand that?
Yes, ma'am, I did.
You're also giving up your right to present any defenses in the form of witness testimony or your own testimony if you chose to do so. You're giving up that right as well. Do you understand that?
Yes, ma'am.
And finally, you're giving up your right to file any motions that would have suppressed the evidence in either case. Do you understand that as well?
Yes, ma'am.
And you understood all the required driver's license revocations on all your counts that I placed on the record?
I had a question right there for you real quick, ma'am, if possible.
Okay.
On the driver's license thing, because, will I be able to, like, and how long will I be able to qualify to get my license? Because I got my license again, so that's why I was, in that month period, I got my driver's license back. I wouldn't pay all the money.
Okay. Well, we don't know the answer to that question. You've got a 6, and a 12 revocations being imposed today by law that we can't do anything about. We don't know as we sit here whether the DMV will put those all at the same time or whether they'll stack them up and stretch it out to a full 2 years. We don't know. And it will depend on how the Department of Motor Vehicles decides to handle it as to whether and when they will permit you to at least try to get a restricted license.
Okay, that's all I wanted to know.
Yeah, so we're not certain. We can't make you any promises on that. We'll certainly try to help when you get out to ensure that you can get that done. But you're at a minimum, I believe Mr. Darrow can confirm, At a minimum, you're going to have to get the DUI school done before you can pursue any of that. So
Correct.
there's a chunk of time here where there'll be zero driving at all. Do you understand that? You okay? You okay with that?
It's not like a chauffeur.
Okay. All right. Very good. I hope you stay in that relationship. All right. The state's going to continue with questions.
And Mr. Darrow, you reserving your matters for appeal in this case?
No.
Okay. Mr. Trio, have you gone over a copy of your score sheet that lists all your priors as well as your 2 current cases? That document that shows all the points and all your prior history and your current charges, did you see that?
Me? Yeah.
Yes,
I have
sir.
33 points.
I'm sorry?
Did I have 33 points, I think?
Yes, that's correct. Very good.
Yes, ma'am.
All right. And have you had enough time to discuss all the rights that you're giving up and everything about both cases with either Mr. Darrow, your assigned attorney?
Yes, ma'am, I did.
Are you satisfied with their advice? Are you satisfied with the advice they have given you?
Oh, yes, I am.
Okay. Is anybody forcing you or coercing you in any way to get you to enter your pleas today?
No, ma'am.
Did anybody promise you anything that we don't know about besides the plea agreement terms?
No, ma'am.
And are you pleading because you believe it's in your best interest to enter a plea to both cases?
Yes, ma'am, I did.
You understand if you're not a U.S. citizen that the pleas could be used against you in a deportation proceeding?
Yes, ma'am.
And also that if you have been in the past or are in the future convicted of any sort of sexually violent or motivated offense, that the pleas could be used against you in what's called an involuntary civil commitment proceeding, should you qualify under the statute as a sexually violent predator. Do you understand that warning as well?
Yes, ma'am, okay.
Okay. And Mr. Darrow, we stipulate the factual basis and venue for purposes of the plea.
Yes.
And finally, sir, you heard me state on the record that one of the conditions of your DUI plea is restitution. Do you understand?
Yes, ma'am.
You understand that you have a right to have a hearing and make the state prove that you owe that, but that by entering the plea, you're giving up that right to have a hearing?
That's the 16,
Yes.
$1,600?
$1,666.59.
And I'll pay that to the gentleman or?
No, to
To the
probation.
what?
It's gonna be a condition
Oh,
of
the
your
probation,
probation.
okay. Yeah, because my insurance, my wife's insurance took care of the bill, but I'll call into that, but I'll take care of that right there, the 1660.
Yes, and that's gonna be paid at $167 per month.
Yes, ma'am.
And Your Honor, if he has proof that insurance has covered that, he can present that to probation and that will show that.
Right. We can sort that out. You can, if it's been paid, you can show proof of that to probation. And if it hasn't been paid, but you're able to pay it faster than that minimum rate, that's also fine. It's just a minimum. We want to ensure that you get it all paid off over time. Okay.
Oh, yes, ma'am.
All right.
Okay, Your Honor, I believe I covered everything.
Okay, Mr. Trujillo, I've read these files. I find there's a factual basis for your pleas. I find that you freely, voluntarily, and intelligently waived your rights. You've knowingly entered these pleas with a full understanding of the consequences. So I'll accept your pleas. In case 21 CF 105, the suspended license misdemeanor, resisting misdemeanor, and possession felony, I'll sentence you as follows. On the 2 misdemeanors, counts 1 and 2, I'll adjudicate you guilty, sentence you to the time you've served, and impose any mandatory court costs that go with those 2 counts. Then count 3 is the count that'll come into drug court. That's the possession. I'll adjudicate you guilty on that. And this is going to be the same sentence that you're going to get on the possession in the other case, 21 CF 377. It'll be the same sentence running concurrently. There'll be 4 years of state probation. The first 2 years will be drug offender probation. You'll have a special condition to comply with and successfully complete the drug court program. That means that everything that you read in our handbook, you went through that carefully, correct?
Yes, ma'am, I did.
Good. Everything in the handbook, plus everything that I ordered today, plus everything that treatment directs you to do along the way, all of that is part of your probation that I will enforce. Do you understand that?
I do know.
All right. Specifically today, I'm going to order you to keep a curfew. It'll be from 10 p.m. to 6 a.m. So you will register your address with probation, and you'll have to be at that address by 10 p.m. every night and stay there all night, all the way until at least 6 a.m. Be prepared to be checked on by members of the probation office and or law enforcement. They will knock on your door at all hours and make sure that you're home doing what you're supposed to be doing. So make sure that you can hear the door and be responsive when they come check on you. Every now and then somebody says, oh, well, my room's in the back, I didn't hear that. And that won't do you a whole lot of good. You need to be prepared to be checked on. So make sure that you understand that. Additionally, your probation officer has the authority to adjust that curfew for certain necessities. Most common is if there is employment that requires you to be out past 10 or to leave before 6 a.m. to go to work. And you would simply need to make any of those requests to probation. They have a whole system where you'll show them your proof of your work schedule and they can adjust that curfew. Do you have any questions about the curfew?
I do not know.
Okay, and Mr. Erlinson, these are the same rules for you, so this is the stuff I wanted you to be able to hear. The next obligation involves meetings. This is something that we leave to the treatment team to decide if they want you to attend meetings, and if so, what sort of meetings, what sort of frequency, whether they want it to be every day or 5 times a week or whatever. But if treatment does make that part of your treatment plan, you'll have an obligation to do that and to document that truthfully. We want to make sure that that you are attending those meetings as you say you will, and we leave all of that to treatment. Do you have any questions about any of that?
No, ma'am, I don't.
All right. Mr. Erlinson's got a question?
No, I don't. I'm familiar with recovery, so
Good.
I know it's important.
Okay, very good. The next obligation, Mr. Trujillo, you've already done, or at least started, which is the clinical assessment. I believe they saw you by video conference to do the assessment. So what that does is that gives you your initial treatment plan. Your obligation is to comply with all of the recommendations for treatment that are in that plan. The other thing I want you to understand is that the clinical assessment will be ongoing throughout your time with us. The clinicians will update that periodically and make adjustments based on your needs, because your needs are likely to evolve over the time with us as you work on things. Your obligation remains the same. It's very simply put, anything treatment recommends, you will need to follow through. And I also like to make sure you have a heads up that our drug court program is designed to treat the whole person. We're not just here to help you with substance and alcohol. So if, for example, in treatment, the clinician has a concern that you may need to see one of their colleagues on the main campus, or that you may need to see a medical doctor for an issue that you have, any of those other referrals will also be part of your obligation. They're not optional. You've got to follow through and work with any other professionals that treatment refers you to. Do you understand that?
Yes, ma'am, I do.
Very good. We had a guy a little while ago just had terrible stomach pain, couldn't even sit through his sessions with David Lawrence, and they told him, you got to go see a doctor for your stomach. He didn't want to, and I had to tell him, you don't have a choice. That's part of the deal. This is something that's affecting your ability to live your life. You're going to have to address it. So it is a whole person program that you're getting into. The next obligation, I especially want Mr. Erlinson to listen because it's very long. These are our sobriety rules. This is all set forth in detail in the handbook, so it should sound pretty familiar. But I'd like to go over it in case you have any questions, and I'd like for you to hear it directly from the judge. So you will be prohibited from having any alcohol. You can't have any alcohol in your home. You can't consume any alcohol. You also can't possess or consume any drugs, any unapproved medications, or any mind-altering substances. You'll be subject to random testing, actually I should say testing, throughout your time with us, and you'll test a minimum of once a week at probation and once a week at David Lawrence. So at least those 2 tests will happen every week. More than likely, you'll be tested quite a bit more than that, but that'll be the minimum that we put in the sentence. No alcohol, no drugs, that's pretty self-explanatory, but I want to go over the other 2 parts in a little more detail. No unapproved medications. You said at the moment you take some prescription medication, but nothing that is geared towards your mental health or towards your substance recovery, correct?
No, ma'am, I don't.
Okay, and that's fine. That may stay the same the whole time we're together, or there may be some adjustments made. I do like to mention that our program offers what's called medication-assisted treatment. You may or may not be familiar with that, but there are 3 FDA-approved medications that are specifically designed to assist with a lot of the challenges in early recovery. They are, at this point, we have medications for alcohol and for opioids. I'm hopeful sometime before too much longer, they develop some sort of a similar medication that addresses cocaine, meth, and other stimulants. But if you are curious at all about those medications, if you suspect they could be beneficial, in your court files, it looks like alcohol and cocaine were the issues in these incidents. So it is possible that those medications could be helpful. What they're designed to do is to primarily reduce craving, but also to assist with a lot of the other things that go on when you're trying to get clean. Things like mood swings, irritability, trouble sleeping, anxiety, all that sort of thing, very normal. And the medications can be helpful. You won't be required. We don't force them on anybody, but I do like to take the chance to advise people that we have those, that you are permitted to use them if you go through the proper channels. You can't go get methadone on the street and be okay, but it is possible to get those medications through proper channels, and I want you to be aware of that. With regard to any prescription medication, whether it's blood pressure pills, psych meds, or medication-assisted treatment, the rules are the same. We'll require you to take it exactly as prescribed. So that means don't take more of it or less of it than you're supposed to. Don't let it run out. If it's supposed to be refilled and kept up, we'll require you to keep any follow-up appointments that the clinician wants you to have to check back and make adjustments. You must never share your medication with anyone else, and you must never take the medication of another person. Those are actually crimes in and of themselves. And then the final part of the rule is this: if you've got a provider outside of our program, outside of David Lawrence, that wants to put you on a prescription medication, you'll need to disclose that right away to your case manager, along with, by the way, any medications you're already on. You'll be disclosing that to probation and to David Lawrence so that we know, okay, he's got blood pressure medication or diabetic medication or whatever it is. We need to know all the medications that you're on. And like I was starting to say, if another provider is going to add a medication for you, you've got to disclose it right away. What we're aiming to do there is to coordinate care with any other providers in your world to make sure we're all working together. What we've had in the past is well-intentioned doctors who may see you. A dentist might want to pull a tooth, and he's going to give you Vicodin and Xanax, and that obviously would be really contrary to what you're trying to work on with us. Now, first and foremost, we encourage everybody, when you see another provider, be upfront with them. Tell them, I'm in recovery, I'm in drug court. I need to do my best to avoid any sort of substance that could cause me a problem. But we're not going to interfere with your medical care. We're not going to prevent you from getting good care, but we are going to be all up in your business. We're going to want to know everything. We're going to require you to sign releases potentially so we can talk to that doctor and make sure exactly what the game plan is. And then we'll provide structure and accountability on our side so that hopefully while you've got to be under that particular medication, that it doesn't cause you any setbacks in your recovery. So all prescription medications must be disclosed right away. And then whatever other instructions you're given, you'll have to follow. Do you understand all of that?
I do, ma'am.
Okay. And then the final part was no mind-altering substances. That's a catch-all for everything else. 3 basic groups. One is the designer drugs that are out there things like spice and bath salts and whatever else they might invent tomorrow. Some of that's illegal, some of it's not illegal for the rest of the public, but all of it's out of bounds for you while you're on probation with us. Additionally, there's some herbal things out there, things like kratom and kava. Those are currently legal in Florida for the general public, but they are illegal for you while you're on probation. You cannot use those substances. And be careful, they are ingredients in products that you can find in a health food store. Herbal pain remedy will often have kratom in it. So you've got to be very, very careful and know what it is that you're consuming, that it doesn't have any ingredients that are banned by our program. All of this is in the handbook. And then finally, there are certain over-the-counter things like cough and cold medication that has mind-altering ingredients. It would cause you to have a positive drug test if you used that while you were with us. So those are out of bounds as well. David Lawrence Center, when you do your orientation with them, they're going to give you a sheet that has a whole list of medications you can safely take for common ailments, common cold, aches and pains, that sort of thing. So you'll have a list of what you can take without any worries. And you do want to be careful to check the ingredients of anything else that you want to use. Generally, I tell people if there's something that maybe it's an exercise supplement, or maybe it's a herbal sleep remedy or whatever, check the ingredients with your case manager before you spend the money to buy it, because some of those things will be fine and some of those things will get you in trouble. And it is your obligation not to consume anything that could get you in trouble. Telling us I didn't know it was in there won't help you very much. Do you understand that whole long rule?
I understood it.
Do you have, oh, good. Any questions, anything that you wanted to clarify, or anything maybe that you're worried about based on lawful things that you were doing before you caught these charges?
No, ma'am.
Okay, all right. We'll move on then. That's it for the really long part. Next, with regard to this possession charge, as we noted, I'll revoke your driving privilege for a period of 6 months on this. Indicate I have no objection to a hardship permit if you qualify, and remind you that we're not sure how DMV will do these multiple revocations, whether they'll stack them up or run them together. On this case, there'll be $100 each for the prosecution and defense of this matter, $215 cost of investigation to the sheriff, plus all mandatory court costs. Then turning to 21 CF 377, this is the possession and the DUI with property damage. On the possession charge, again, identical terms to what I just announced. You'll be adjudicated guilty, given that 4 years of state probation with 2 on drug offender probation, all the conditions of drug court that I just explained. That'll run concurrently, so it's a total of 4 years. I'll again revoke your driving privilege for 6 months, indicate I have no objection to a hardship permit, and remind you I don't know how the DMV will organize the timing of all that. On this case, there'll be $100 each cost of prosecution and defense, $509.50 cost of investigation to the sheriff, plus all mandatory court costs. Then count 2, the DUI, I'll adjudicate you guilty, place you on 12 months of probation, also running concurrent. So all counts, all cases are concurrent. I will impose all of those same drug court terms that I've just articulated. Plus there are a number of statutory terms required for the DUI, and they are these. There'll be 50 hours of community service that you'll have to complete. You'll have to complete the appropriate phase of the DUI school, as well as a victim impact panel, a 10-day impoundment of your vehicle, a 6-month ignition interlock device on all of your vehicles. That will start whenever you reinstate your driving privilege. So that may or may not be while you're still on probation with me, but whenever you do get the license reinstated, 6-month ignition interlock device on all of your vehicles. There'll be a $1,000 fine plus any mandatory court costs that go with the DUI. Restitution to the victim named in your report, $1,666.59. We will require you to pay that at a minimum monthly rate of $167 per month. We'll give you 30 days grace period to get started on that from your release in custody. And again, if you've got documentation that shows it's already covered that, you'll just show that to probation It may be partially or fully already covered, and probation can look that over. I'll order you to have no contact with the victim named in your report. And on the DUI, I'll revoke your driving privilege for a period of 12 months. Indicate again, I have no objection to a hardship permit. So you may have a revocation for as much as 24 months, or it may be that they fold them together, which would be the 12. And again, the existence of all three may also affect when you would become eligible to get the hardship permit. When you get out, have your chauffeur, as you said, drive you over to the DMV office, and you can investigate that with them as to how they're going to organize all that. It'd probably take a few weeks for all of those records to actually hit Tallahassee, but you can look into that after you've gotten set up with us. Those are all the sentencing terms. Do you have any questions about any of that so far?
I have a question in my opinion, and I don't know if it will help, but is it possible that any of those hours, or any of those fines or court costs be done by doing public service hours?
Yeah, talk to me about that when I've got you up here, Mr. Erlinson, and we can discuss that. Yeah.
I'm saying the same for him, though. I mean, is that possible? I mean, I don't know if that's what he wants to do, but I know that, in my case, it's what I think.
Yeah, typically I can do that if need be. Really, the only red hot issue while you're with us is the restitution, and that you can't work off. The court costs and things, we're patient about that. We're going to require you to be working, but we're also going to let you worry about the court costs a little later after you're done with all the intensive treatment and so forth. So we won't jam you up on that. And if it starts to get tight on time and you still don't have the funds, yes, we have occasionally worked and permitted community service, but typically our folks pay those. It's just don't worry about fixing that in the first week. All right. Mr. Trujillo, did you think of any questions about any of the sentencing terms that I've gone through?
No, ma'am.
Okay, let me go through some paperwork with you then. All right, and I see the notice of confidential information that goes with the contract, correct? All right, so first I want to address the score sheet, and Mr. Darrow, I know this was already addressed, but I'm looking at a score sheet with 33.5 total sentence points, and that's translating to 0 as the lowest permissible prison sentence up to 10 years statutory maximum. Is that what you all reviewed?
Yes, I confirm with Mr. Dixon that you, the score sheet you provided.
Any objection to the court accepting and relying upon that for purposes of the plea?
No.
Okay, and I heard Mr. Trujillo confirm his understanding of it, so I will sign off on that. This is a guideline sentence. Mr. Trujillo, the only thing I like to note at this point about the score sheet is just to remind you, you didn't score out to any mandatory prison time today. Of course, you could have faced up to 10 years, but you've got a probation outcome. You've got a possibility of walking out of that jail in a few days and never doing another day of jail. But I do need you to understand that this score sheet remains in play all the way until I actually terminate your probation successfully. So if you're brought back before me on a violation of probation, if the state attorney can prove a willful, substantial violation, then these penalties come back into play and you could once again face up to 10 years prison. Do you understand that?
Yes, ma'am, I did.
Okay, very good. I've got people with score sheets twice as bad as yours, and I've got other people with score sheets that aren't as severe. Doesn't make a hill's worth of difference to me, but I do need you to understand that you've got high stakes all the way until you successfully complete this probation.
Yes, ma'am.
Any questions for me or your lawyer on that?
No, ma'am.
All right, I'm just going to sign a bit more paperwork here. I've got an order that will set your probation fees at 0 for basically this first year while you're doing the in-court portion of drug court. As you saw from the handbook, it takes a minimum of a year to get through the in-court, and then you've got a minimum of a year of aftercare and probation, just slowly stepping down to less and less supervision. So for that first part, the first year, I'll say, probation fees will be 0. That should be welcome news to Mr. Erlinson as well. That's a little less financial pressure while you're in the most intensive part. Then once you move on from drug court and you're still with aftercare and probation probation will start charging you supervision fees. The next order that I have is an order allowing the team to discuss your basic healthcare information. That is typically confidential. And with this order, David Lawrence Center will be able to share minimal information with the rest of us on the team. They'll never talk to us about what you discuss in treatment. They will never violate that confidence. They will simply let the team know that you're showing up, you're participating, your drug test was clear or your drug test was positive, just the basic information. And as a team, the rest of us will keep that confidential from the rest of the world. Do you understand those protections?
Yes, ma'am.
All right. I'm going to sign the restitution order that we discussed. And I've got to initial, it looks like above and below. And then also there'll be no contact with the gentleman who's the owner of the other car.
I don't really know.
I figured he was probably a stranger, so that's fine. There'll be no contact directly, indirectly, or through third parties with him. Sounds like that should be easy enough to do. And then I just want to go over the contract. I've got here a 3-page drug court contract. Looks like you signed it May 6th, so about a week ago. Does that sound right?
Yes, ma'am.
And
Yeah.
did you go through that carefully with your attorney?
Yes, I did.
Did you understand what you were agreeing to when you signed this contract?
Yes, ma'am, I did.
Do you have any questions you want to ask me or your attorney about the contract or anything else we've discussed?
No, ma'am.
Are you comfortable that you can do everything that I've listed out here today and that's in this contract?
Yes, ma'am.
All right. And then the last thing is I want to just make sure the contract says what we think it does. Paragraph 4 of the contract is the part where the state attorney makes a promise back to you. What she's indicated there is that when you successfully complete drug court, aftercare, all the probation, you get the restitution and costs all paid off. If you get that done in less than 4 years, you can ask me to terminate the probation early. And if and when I grant that, that will end your obligation to the court on both of these cases. Is that your understanding of the deal?
Yes, ma'am.
You know that you do have felony convictions and that the charges, none of these charges have been dropped here today except for 2 of the DUI charges. You understand that?
Yes, ma'am, I do.
Okay, very good. All right, and that request for early termination. So the way our program is structured, the fastest you could complete is 2 years, and you've got up to 4 years to complete. So somewhere between that 2 and 4 year mark is when typically I'm getting requests from people to consider terminating their probation. Do you understand that?
Yes, ma'am.
Okay, very good. All right, and then the final piece of paper I know is always the best one. This is your release order. And this is indicating that on Monday, May 14th, you would be released to the custody of a David Lawrence Center representative to begin our program. It looks like 1 o'clock is the estimate of when they will be here to get you and get you started. They'll take you across the street to state probation and then take you to deal with whatever else you need to deal with. Where are you going to be staying? Have you got a residence somewhere?
Yes, ma'am, I got my house in Lockley.
Okay, you live in Immokalee?
Yes, ma'am, I do.
And who lives under the same roof with you?
Me and my wife.
Any kids or anyone else?
No, my children are already grown and married.
Okay, so just you and your wife at home?
Yes, ma'am.
That sounds lovely. All right, well, and your wife, I assume, is supportive of what you're trying to do here?
Yes, ma'am, she is.
Is your wife clean and sober herself?
Yes, she's on good work.
Okay, all right. I can never really make assumptions about parents, children, spouses, siblings. You know, sometimes folks are really squared away and other times they've got their own struggles and they're not able really to be as supportive of you as we might need them to. Hopefully your wife will understand we're going to keep you very busy. We're going to need a lot of your time. She might not get as much of your time as she might like. You do have a lot going on in Naples, so I don't know if she is free to constantly be running you back and forth to Naples or not. Are you worried about transportation at all?
No, ma'am, we own a business in a market, so she don't have to work. She has to work.
Okay. All right. But do you run that business?
Yes, my father owns it and I'm the manager, but I don't gotta be there. We own a mechanic shop.
Okay. All right. Because it is a little bit difficult to run a business and do drug court. It can be done, but I want to be very, very clear with you. Drug court must always, always come first. It has to come ahead of your wife. It has to come ahead of your kids. It has to come ahead of your business. You okay with that?
Yes, ma'am.
Okay, I know I'm asking a lot, but that's the only way this is going to work. And so if everybody's on board with that, then you've got already a tremendous head start. You've got a safe place to live. You've got work at a business that supports your efforts in drug court. You've got family rallying around you to support you. Those are huge advantages. Do you see what I'm saying there?
Yes, ma'am, I did.
Good, good. So I'm excited for you. I like that you've already got some good things going for you. We just need those people to be patient and understand that we're going to take a lot of your time and energy away from them, and hopefully they'll be able to put up with that.
Yes, ma'am.
Okay. Do you have any questions about any of that I've gone through?
No, ma'am.
Let me just go over just a couple more things then, and we'll wrap up, and I'll get to Mr. Erlinson. First, just a couple things in terms of manners. We've got some rules about manners and etiquette here. Right now, court is being done just like this on video conference. And I know that camera is aimed away, so you can't even see the voice that's talking to you right now. Sorry about that. But we'll have everything on video conference at least for a little while longer. I'm hopeful the Chief Justice of the Florida Supreme Court, who runs the whole court system, will start to give us some idea when we might be able to have you in person in court. But either way, I want you to handle anything that you do with the court and anything you do with the David Lawrence Center with the same level of respect. So that means I want you to always handle yourself the same way that you are right now. If you were sitting here in my courtroom, you would not be smoking, you would not be eating, you would not be drinking, you wouldn't be talking on the phone. You'd be focused and you'd be engaged. And that's really mentally what I want you to think about when you're at a treatment session, whether it's by video or in person, and when you're in a court session, whether it's by video or in person, that same level of respect. So no eating, drinking, smoking, vaping. I don't want you playing with pets or kids. There shouldn't be anybody in the room with you distracting you. You want to put your phone in a mode. If you're using your phone to connect with us for a video conference, it can't be ringing and getting a whole bunch of texts. You can, I think, put it in airplane mode so all that stuff shuts down. We want you focused and paying attention. And we require that of all the guys because you're going to school on each other. You're going to learn from each other. You're going to help each other. And you got to pay attention in order to do that. So there's a level of respect that will require you to show yourself, each other, and the court and the treatment team. And that's the point of those manners rules. We also have a dress code for when you're in person, really, if you're in video too. All of that's in the handbook, and David Lawrence Center will go over all of it with you. Nothing fancy, but again, just demonstrating respect for the significant program that you're working on here. Any questions about that?
No, ma'am. All
All right, last bit, and then I'll let you sit down. The main thing that I save it for last because it's the most important. I want you to, of everything I've told you, the only thing that you absolutely have to remember is this. Honesty is the central principle of drug court. It's the only thing you have to do perfectly. And the good news is you're already capable of doing that perfectly. Lots of other stuff is going to be a work in progress, maybe for many months. And we understand that, and we'll be very patient. We can manage mistakes and setbacks very well in this court, but honesty is critical. And so what I want you to think about is this. I look at honesty from two different angles. From the front side, I think of it in terms of preventing problems, being honest with us about anything that might cause you an issue. Heaven forbid you get home and your wife is giving you a really bad time. She's just not understanding what you're trying to do. Or your father's giving you a hard time. He's asking you to do way too much at work and you can't do both drug court and work. or you're having cravings and you want to use. Old friends are hanging around and you can't really shake them. Whatever it is, you're not in trouble, but if you stay on that path, it could create a problem, right? And so we're going to ask you to be honest with us about what's going on for you, what's got you stressed, what's got you overwhelmed, any of those things. You're in a very different court now. This is, I call it the judgment-free zone. You are not going to freak us out by letting us know what's going on, but you are most likely going to save yourself a lot of trouble and heartache. We'll help in any way that we can with whatever you share with us. If you keep it to yourself, chances are high, eventually it's going to cause you a problem. And we're going to be sitting there saying, Mr. Trujillo, all you had to do was tell us, we could have helped you. Okay, so that's prevention honesty. And then on the back end, if you do make a mistake, if you do mess something up, if you fall short in any way, you simply need to let us know right away. Okay, and that includes if you pick up and you use. This is not like regular court. I'll say it again. If you relapse on a Tuesday night, you need to be calling your case manager first thing Wednesday morning before you do anything else. Calling and saying, look, I used last night. I messed up. I need help. Whatever words you want to use, tell us exactly what happened, and I will keep you out of that outfit. If you're fully and promptly honest, we'll let treatment help you with whatever went wrong, with whatever caused you to step off the pathway there, and I'll stay out of your way and there won't be punishment. That's a pretty big deal. You understand what I'm talking about?
I do, ma'am.
Okay, all right. So if you can spend these next couple of nights in jail just wrapping your head around what it's really going to feel like to be honest and open with everybody who's trying to help you, then you're going to come out on Monday ready to take this on, and we're really excited for you. I'm going to see you, I'll see you Tuesday afternoon for your first session of drug court, which again continues to be just by Zoom video conference. Your case manager will help make sure that you're all set up to do that. You need to make sure that you have a quiet space where you can attend court. I don't want you to be at work with people yelling at you in the background and so forth, okay?
I got my house set up already for that.
Okay, good, good. If you've got decent Wi-Fi, that's even better. Okay, fantastic. Well, that'll make it pretty easy for you. And again, your case manager will double check that you've got what you need there. I think that's everything, Mr. Trujillo. Did you think of any questions about any of that?
No.
Okay. All right. Well, welcome to drug court. I'm going to let them take your fingerprints and you're all set. We'll move to Mr. Erlinson in just a moment. I've got to review the judgments. Do you want to start at the top? Sorry, thanks. Okay, so this is the 105 case. Okay, you can scroll down for the possession, please. Great. Okay. The 90 and 90, we don't actually do. We phrase that differently. So it's just, I don't know if you want to, you want them to take that off the judgment, or you just take it off. Yeah, it's basically meetings if directed. Okay, let's see if there was anything else.
Oh, is that the right one? Yeah.
So then the other thing you can take off is substance abuse evaluation, follow recommendations. It's the third line, because you've got the clinical assessment, follow recommendations, which is, well, I know our language has evolved a little bit to be more precise. So stay with me on that possession for 1 second. Let me just see if there's anything else. Adjudication, alcohol, okay. Okay, perfect on the testing. Okay, I think we're good on that. If we can turn to the 377 case. Okay.
Money is good?
I think so. And then, so yeah, you can take off that substance abuse. Are you comfortable with that as well on the DUI, because the clinical subsumes it? I don't know that it'll matter one way or the other. If you want us to leave it on the judgment, we can.
I think we have to, because it's statutory on the UI.
Okay, we'll just take it off on the possession.
Okay.
And clinical assessment, everything, all things concurrent. Okay, and then we'll look at the DUI. And this one, we will leave the substance abuse evaluation on it. You can take off the 90/90, yep. And 50 hours, DUI school, victim impact. You can probably take off the random breath urinalysis because you've got it below as the testing twice a week. So it's like the 5th line. Well, no, I'm sorry. It's, yeah, right there. Yeah, I think you can take that off because it's redundant. The impoundment we've got, no contact we've got. And then it's the, okay, there's restitution. Here. I think the monthly is 167 even. Monthly minimum on restitution is.
Oh, I thought you said 167.30.
No, to 167 a month to begin 30 days. And you got that. So 167.00. Okay, that's okay. So we got the 30-day grace period, testing twice a week. That's why I was saying you could take out random breath urine because you've got testing twice a week. And then we've got the concurrent drug court interlock on all vehicles. That interlock, oh, it says down below, it's 6 months. Okay. Okay, I think we're fine. And then the null pros on 3 and 4. Okay, I accept.
Okay, thank you.
Okay. All right, we ready to address Mr. Erlinson?
Yes, sir.
Judge, if I don't think I'm needed anymore.
Sure, that's fine. Thank you. Good to see you. In jail, if Mr. Trujillo can stick around and listen in, great. If you need to take him back, that's fine.
And if you guys need me,
He's already gone, you said?
Yes.
Okay. All right, fair enough. Okay.
Are you asking for $100? Are you asking for $100?
Yes.
Okay. Good morning, Mr. Clark here for Mr. Erlinson as regional counsel.
Yes, Judge.
All right, and we have Mr. Erlinson present. Good morning again, sir.
Morning.
And I'm going to ask the state attorney to go over the terms of the offer for Mr. Erlinson.
Judge, before we do that, there's one thing that Mr. Erlinson may not have information on based on our conversations a couple days ago.
Okay.
We were working on trying to see if St. Matt's House would accept Mr. Erlinson, and they apparently came back yesterday and indicated that they would.
Okay.
You know, because he had some difficulties before. That was obviously something that the program was contingent on, or we would have had to go through some other courses. So, Mr. Erlinson, you will be accepted to the St. Matt's House. So we should be able to, we'll be able to go forward today.
All right, great, thank you.
Thank you, Judge.
Wonderful.
May I be seated, Judge?
You may, yeah. Okay, so Mr. Erlinson in 19 CF 1924, and the terms for him are?
He's going to admit a violation of probation for the charges of grand theft and fleeing and eluding a law enforcement officer. That would be violation of condition 3. His probation will be revoked. He'll be resentenced. He already was adjudicated previously to a new term of 4 years of state probation, the first 2 of which will be drug offender, counts to run concurrent. Conditions would be successfully complete drug court following all recommendations, 10 p.m. till 6 a.m. curfew unless modified by the court of probation. Recovery support group meetings if directed by treatment, submitting 2 reaction sheets to case manager if directed to do so. Having a clinical assessment and following all recommendations. Being subject to being subject to testing for alcohol, controlled substances, and unapproved medications 1 time per week at a minimum by probation and 1 time per week at a minimum by treatment. and no possession or consumption of alcohol, nor frequenting any places that primarily sell or serve alcohol. There's $100 cost of prosecution. Any previously ordered no contact and no trespass orders will be carried forward. And the previously ordered driver improvement school will also be carried forward. If he's completed that already, then it won't be a requirement, but if he is not, then it will be a condition of the new probation. The restitution previously ordered will also carry forward and be paid at a minimum of $100 per month, starting 30 days from the defendant's release from custody. And Your Honor, there is one other caveat in this case, being that he does have a prior aggravated assault conviction from out of state that makes him a violent felony offender of special concern. You're right, as the statute requires us to have a hearing, he is admitting his violation of probation. We're putting the terms and conditions on the record. I believe that we can consider that the statutorily required hearing.
Okay.
You have the same form for Your Honor to fill out, making the findings of whether or not he's a danger to the community. As far as the state is concerned, the prior is it's not the current offense that makes him qualify under the statute. Has been found to have a substance abuse issue. His treatment is going to be a condition of his probation. And the basis of his violation is not being home on probation. Like to check on him, it's also not a violence in any way violation of his probation.
Judge, for the record, we would ask that you make a finding that he is not a danger to the community. We did not discuss that, Mr. Ellenson and myself. I didn't discuss that with the state. However, it seems as though hopefully it will be a moot point if you agree to that.
Okay.
And as the state's not objecting to it, but that would be our request, not to find him a danger.
Okay, and I'm happy to do that. Mr. Erlinson, I will take the opportunity to note, I've got a couple other guys in drug court right now with the same situation based on criminal history, and they're doing great. They're great guys to work with. But I do want to just give you the heads up so I don't sneak up on you. That criminal history does really give you higher stakes. It gives us a little bit less flexibility in how we address things. If you violate this probation, as you're seeing already right now, there's a lot of extra layers of formality and caution. So it does frankly just make it even more important that you commit yourself to being careful and really working this program, because I always feel a little bit bad that the guy sitting next to you in group could do the same thing wrong and not have as big of a consequence. It's because of your history is going to really hem us in a little bit. Do you understand what I'm saying there?
I totally understand, Your Honor. I mean, this is by far not the easy way out. For me to take drugs court is actually a hard decision because I could have went and done 24 months, another 5 months, and then out.
Yeah.
But now I'm putting myself in a position where it's a do or die situation. It's either I do it or, I could die. And that's, I came here 3 years ago. That's what I came to Florida for.
Okay.
I promised myself to die.
All right. Well,
and,
I understand what you're saying. I respect and appreciate that. And it sounds like you are our kind of guy. That's exactly the person that we're here to help. So I just encourage you keep that level of focus and commitment all the way through. It's pretty easy to have it now. When you get out and things get more comfortable, you just need to consciously keep that focus because your history, until we can get you successfully through this probation, your history just adds a little bit of a potential complication. But if you're doing what you're telling me now you're committed to be doing, then it's going to be fine, and nothing's going to look or feel any different from you than it is for anybody else in drug court. It's just if you have a violation, it gets complicated. So just be careful.
And Judge, if I may just, because we didn't talk about the danger to the community type of determination that the court can make, if you have a violation in the future and the judge determines that you are a danger to the community, the judge could determine that you would not get probation, and probation is not something that would be good for you. So what they could do is sentence you to the maximum prison sentence on that particular case, or just prison from the guidelines all the way up. And that's the difference. You're not gonna have those options in the future. It's not gonna be a situation where you could say, like, well, I have a violation of this reinstatement me. The judge may say that you're a danger to the community and you will not be eligible for probation based on the determination. So,
Right.
this judge.
Let me just ask a question. Does that mean if I commit a crime that would endanger somebody? Is that what you mean by it, or?
It's based on your past history, sir. You know, based on the violence of the Illinois cases, they could make a determination that, you know, you're not somebody who should be on probation because you're placing a danger on
Right.
police.
But his question's well taken. If, for example, he violates by committing some violent act, then his history would allow me to say, no more, Mr. Erlinson, I can't safely manage you in drug court. I find you to be a danger. If Mr. Erlinson violates, and we've had this a lot, if he violates by relapsing and just not being honest with us about it, it's going to be based on the facts. So I'm not going to come out of left field at Mr. Erlinson, but if his behavior creates facts that then give me a basis to make a different finding next time, today I'm going to find he's not a danger. But if he goes out and acts in a dangerous manner, those facts would make him vulnerable, coupled with his history. But I don't want him to be unduly concerned that nonviolent behavior is going to cause me to suddenly come down from on high and call him violent and send him to prison.
And again, Judge, this is you.
I know.
There's also there's also a possibility that, you know, a violation gets thrown to another judge, and I can't control or speak for those judges. So again, if the judge is saying don't be unduly concerned about it, this is Judge Martin here. I can't speak for other judges. So, you know, just, you know, obviously, you know, govern yourself accordingly. I think you're gonna do great. But the issue is that danger is out there, so please keep it in mind.
Sure, and very, very good point, that your criminal history is going to make you vulnerable to enhanced sentencing until you can lay down some track record of getting things done successfully and not being violent. So for today's purposes, I'm happy to give you the opportunity. Find that nothing in front of me today makes me worried that you're a danger to the community. But your attorney's point's well taken. Your history is your history. And it just puts a little added motivation to you to really check yourself and make sure that you're operating in a way that's going to, you know, keep you in compliance with us and help you take advantage of this opportunity.
Thank you very much, Your Honor.
All right. And so, Mr. Erlinson, do you understand all of the terms and conditions that the prosecutor set forth a few minutes ago?
Yes, I do.
You want to accept those and resolve your violation this way by coming into drug court?
Yes, I do.
I'm sorry, I apologize. I know he had a question earlier concerning doing some community service for some of these fees and costs. I don't know if that's something that we can address at this point. I understand it won't be for the restitution, but
right.
That's something before we can proceed.
With that, I'm going to table that and ask him to make that request if he's getting closer to the time when he would actually terminate probation, if he's still unable to have had them paid. But the vast majority of our folks pay their court costs in their second year with us. I'm not going to be hassling them about any of that. So, Mr. Erlinson, if you are still struggling to get those costs paid after you have moved on, that's what we call graduation. After you've moved on from the first year, the part you spend with me, and you're in your second year doing the probation, if you're still not able to get that stuff paid off, just he can let probation know directly. He won't even have to bother you. I'll be happy to do an order that lets you work community service, but I'm confident the vast majority of our folks, by the time you're at that point, you're working, we're not hitting you with a whole bunch of expensive treatment sessions. You should be able to get the court costs paid, and that's our preference.
Thank you, Judge. I apologize for.
No worries at all. Mr. Erlinson, if you're okay with all of that, let me have you raise your right hand to be sworn in.
Do you swear or affirm that the testimony that you give shall be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, the state attorney will ask you some questions to qualify your admission.
Sir, can I have your name, your date of birth, and the last four of your social security number, please?
My name is Eric Richard Erlinson, and my last four of my social are 5016.
And what's your date of birth?
February 16, 1970.
Okay, thank you. And sir, where were you born?
Chicago, Illinois.
And how far did you go in school?
I got a bachelor's degree in science.
So then I assume that you don't have any difficulty speaking or writing in English, is that correct?
I don't.
Okay. Do you have any history of mental illness?
No, other than depression, after my son died, I had a bout of depression. If you lost a child, I'm sure you would too.
Yes, I imagine so. Are you under the influence of any alcohol or drugs right now?
No,
Are you on any medication given to you by a doctor?
I am for high blood pressure, yes.
Okay, then I assume that has no effects on your mind, is that correct?
No, no,
Did you understand everything that we placed on the record in all previous conversations with your attorney?
yes, I do.
Okay. In 19 CF 1924, you were previously placed on probation for grand theft of a motor vehicle and fleeing to elude a law enforcement officer, is that correct?
Yeah, it was stupidity.
I'm sorry?
It was stupidity.
Okay. And do you,
I mean, I shouldn't have done it. I was not thinking clearly. I was, it was stupid. That's why I said it was stupidity.
okay, so you admit to being placed on probation for those charges. Were the terms and conditions of your probation explained to you by your probation officer?
Yes,
Okay, and did you understand those conditions?
yes,
Do you admit to violating condition 3 of your probation by changing your residence back in November of last year without getting permission first from your probation officer?
yes.
Did you read a copy of an admission form in the jail?
Did I what, man?
Did you read a copy of the violation of probation
Yes.
admission form?
Yes, I did.
Did you understand that form?
Yes, I do.
You understand that you're giving up your right to have a hearing and make the state prove that you did in fact violate your probation by admitting that you did so?
Yes,
You understand you're giving up your right to see the state's witnesses testify and to have your attorney cross-examine them on your behalf?
I am.
You understand you're giving up your right to present any defenses you had at all to the violation?
I made a mistake. It's my client was told milk. I made a mistake. I can't change it.
I understand that, sir, but we have to have the answers to these questions on the record. That's why I'm asking.
Yes,
Okay. You understand that each of your charges that you're being placed back on probation for carry a maximum penalty of 5 years in jail if you violate your probation again?
yes, I do.
Have you had enough time to discuss the violation and all the rights you're giving up with Mr. Clark?
Yes,
And are you satisfied with his advice?
very.
Has anybody promised you anything other than the terms of the plea agreement to get you to admit your
No.
violation? Anybody threatened you or coerced you in any way?
No,
You admitting because you believe it's your best interest to do so?
this is my best interest. Yes, it is.
Okay. And do you believe you'll have the ability to make that restitution payment of $100 a month starting in 30 days from your release?
Yes, I do.
And Mr. Clark, have you gone over all the discovery and the violation as well as the score sheet with your client?
Yes.
Mr. Erlinson, did you go over the score sheet with Mr. Clark?
Yes, I did.
Do you agree that absent the plea into drug court and you're qualifying to enter a plea into drug court, you would have scored to 14, well, you would have been sentenced under the guidelines to 14.5 months in prison?
Yes,
You understand that should you violate your probation again in the future, that you'll score higher than that?
yes,
You understand if you're not a U.S. citizen, the admission could be used against you in a deportation proceeding?
no, I'm a United States citizen. I don't worry about that.
I understand, sir, but remember, we have to have the answers to all these questions on the record. That's why I'm asking.
Okay, yes,
You also understand that if you have been in the past or are in the future convicted of any sort of sexually violent or motivated offense, that the admission could be used against you in what's called an involuntary civil commitment proceeding if you qualify under the statute as a sexually violent predator. Do you understand that warning?
yes, I do.
Okay. All right, we attended the admission.
Okay.
Clerk, you need to sign the contract.
Okay, Mr. Erlinson, I will accept your admission, will revoke the old probation and resentence you as follows. Again, it's admission to violating condition 3. You've already been adjudicated guilty of these 2 felony charges. I'll place you on a new term of probation, 4 years state probation, with the first 2 being drug offender probation. That'll run concurrently for the 2 counts, so it's a total of 4 years. and the sentence will be the same on the 2 counts. As I indicated, you'll have a special condition to comply with and successfully complete the drug court program. That means everything you read in our handbook, everything I specifically order here today, and everything treatment directs you to do along the way, all of that is part of your probation that I will enforce. Do you understand that?
Yes, I do.
All right, so you heard me go through all of this with Mr. Trujillo. I'll abbreviate a little bit. The first is that same 10 p.m. to 6 a.m. curfew. You'll have to be at, and I know you're starting out at St. Matt's, correct?
Yes.
Okay, great. So a lot of our rules and their rules overlap, which makes it pretty easy. But we will come check on you at St. Matt's to ensure that you're there keeping curfew like you're supposed to, that 10 p.m. to 6 a.m. And when you move out of there, obviously the curfew continues. You will be checked on. You need to make sure that you are available to respond to those checks and demonstrate that you're there and you're accountable. And again, your probation officer has the authority to adjust that curfew if you end up with employment that would make that curfew difficult. So just take any of those curfew questions to probation. When you meet with them, they'll explain to you exactly how they manage those questions. They've got a little system that seems to work just fine. Next is an obligation, if directed by treatment, to attend meetings and to truthfully document your attendance at those. That's AA, NA, Smart Recovery, Celebrate Recovery, any one of a number of different peer-led recovery support groups. And treatment will tell you all about what the options are, how you can access them, and they will dictate how often you are to do that and how you'll document it. Your obligation is simply to be truthful and follow through. Do you understand that?
I do.
All right. And then next is the clinical assessment, which you've already had. So we have your initial treatment plan. You've got to follow all recommendations for treatment and understand that that assessment will be updated throughout your time with us. The recommendations may change. They may get more intense or less intense. They may drop down and then go back up. We're really just trying to address whatever is clinically required in the moment for you. So your obligation is to comply with whatever treatment recommends. Do you understand that?
Yes, I do.
And as I mentioned to Mr. Trujillo, that can also involve recommendations and referrals for things that go beyond, strictly speaking, substance use treatment. If treatment believes that you might benefit from support from the main campus providers or a medical provider or a third-party provider, we work with a lot of folks in the community. We want to take care of the whole Mr. Erlandson. So I think it's probably quite likely that substance was a major part of how that criminal history got to where it is, but there's probably a lot more to you than just that. And we're going to try to help you with everything that has been a barrier in the past to your wellness and your success. So your obligation is follow through with all treatment recommendations. Are you okay with that?
Yes, I am.
Good. Next is that sobriety rule. You can't possess or consume any alcohol, can't possess or consume any, can't have any in your home, can't go to any bars or taverns or places that primarily make their money from alcohol. You can't possess or consume any drugs, any unapproved medications, or any mind-altering substances. You will be tested throughout your time with us, and a minimum of once a week each from probation and David Lawrence. So between them, they'll get you at least twice each week. Probably it'll be quite a bit more than that. You heard me go through in detail, there's no alcohol, no drugs. You heard me go through the no unapproved medications rules and the no mind-altering substances rules. Did you have any questions or anything you wanted to clarify about those rules?
No, I don't. I've read everything that was sent to me. I asked a lot of questions and,
Good.
this was a hard decision for me to make. I could have taken the easy